Hi everyone, my name is Beth Brown and I am counsel in the pensions group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. The time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. Hi everyone. As it's nearing the end of the year, in this episode I will do a case law update. I will talk about 3 key pension law cases which have been decided this year. First, I will look at the EU Court of Justice decision on the transfer of personal data from the EU to the United States, a case more commonly known as Schrems II after the lead claimant. Next, I will turn to a recent determination by the Pensions Ombudsman on a complaint by a member of delays in processing their request to transfer out. Finally, I will look at a High Court decision from last month which rectified 3 successive scheme trusting rules in order to remedy a mistake made in 1998. So, starting with the data privacy case, the European Court of Justice handed down its judgment on the 16th of July this year. In this case, Mr. Schrems brought a complaint to the Irish Data Protection Commissioner that the USA does not offer sufficient protection for personal data being transferred to their country. In the USA, the security and intelligence agencies can require internet service providers to hand over information on individuals. The EU's General Data Protection Regulation, or as we all more commonly and I'm sure fondly know it as, GDPR, requires specific safeguards to be met in the transfer of personal data to non-EEA countries. One such safeguard is the adequacy decision. This is where the country receiving the information must have an adequate degree of protection for personal data in line with what is expected under the GDPR. The Privacy Shield, one such adequacy decision, was adopted by the European Commission in 2016 and allowed personal data transfers between EEA and US-based businesses. In this decision, the court deemed this Privacy Shield to be invalid and challenged some of the standard contractual clauses. This was on the grounds that it fails to protect against unnecessary and disproportionate access to EU personal data by the US intelligence agencies. Trustees and other practitioners should be aware of this development in data privacy. While it is expected that the USA and the EU or UK will agree some acceptable alternative to the Privacy Shield, permitting international data transferred to the USA at some stage shortly, in the meantime, trustees should discuss these issues with their advisors and service providers, and in particular consider an alternative permitted safeguard to be able to continue to transfer data to the USA. Trustees ought to be confident that members' personal data is either not transferred to the United States, or, if it is transferred, that it is adequately protected. Turning to maladministration and investment loss, now I will look at a determination by the Pensions Ombudsman on a complaint by Mr. T. Mr. T was a member of a small self-administered pension scheme. He held cash and stocks with a bank and $220,000 in cash with the administrator. Following notification that the bank would be closing its pension trader accounts on the 30th of June 2016, Mr. T emailed the administrator to start the process of transferring his cash and stocks out to enable him to invest in other ways in anticipation of the Brexit referendum and the UK stock market decreasing in value as a result of that referendum. Mr. T insisted that the transfer must be completed before the 30th of June 2016, so the bank would not be able to unilaterally liquidate to cash. The cash was transferred by the 19th of August 2016, and the stock was transferred by the 3rd of October 2016, which, as I'm sure you would have picked up on, are both after the 30th of June date. Therefore, Mr. T complained that the administrator had caused undue and unavoidable delays in the transfer, which caused him financial loss. The administrator argued that it had carried out its duties in a satisfactory manner and within acceptable timescales. It argued that the first time Mr. T had mentioned the referendum vote was on the 23rd of June 2016, the actual date of the vote, and that if Mr. T had wanted to speculate on the outcome of the vote and its impact on the stock market, he was free to do so with the trading facility it offered, which Mr. T was aware of as he had been known to use it previously. However, the administrator did accept that there had been 2 instances of maladministration on its part, in the form of 1, a delayed response to an email from Mr. T, and 2, not being aware of Mr. T's intention to make a partial transfer earlier. As such, the administrator offered Mr. T £100 compensation. Originally, the Ombudsman held that there had been maladministration by the administrator, but the tests for establishing financial loss by Mr. T were not satisfied. However, it noted that significant distress and inconvenience had been caused to Mr. T, and in light of this, instructed the administrator to pay him £2,000. Mr. T appealed. The High Court allowed the appeal. It held that there was no difficulty in establishing reasonable foreseeability for the purpose of loss, as a request for a transfer out is for the purpose, or the possible purpose, of investment, and if there is a delay, the investor will, or may, lose the opportunity to invest over that period. Therefore, the Ombudsman had been wrong to conclude that Mr. T's loss was not measurable. The Ombudsman should have considered the position if the transfer had been made on a non-negligent date. The High Court sent the determination back to the Ombudsman. The Ombudsman reconsidered the matter and held that the administrator was required to make good Mr. T's loss with interest, as it had been caused by the administrator's maladministration. The Ombudsman also took the view that the transfer should have occurred by the 23rd of June 2016, the Brexit referendum date, at the absolute latest, in light of the correspondence between the parties earlier in that June. On the basis that Mr. T had satisfied the requisite tests in respect of loss, and if his transfer had been made when he wanted, Mr. T proved he would have received a profit of about £43,700, the Ombudsman held that the administrator was required to pay Mr. T compensation equal to this £43,700, plus interest. This is an interesting case for schemes and administrators alike. It is important to remember that the principles of law applied in this case have been long established, and it's incredibly rare for the facts of a case to allow them to be applied in this way. This decision involved a unique set of facts in the run-up to the Brexit referendum in 2016. But that aside, it is a timely reminder of the need for schemes and administrators to act promptly when dealing with member requests, such as transfers out. I will finish off by talking about a case about rectification of a mistake. The decision by the High Court in SPS Technologies Limited was handed down on the 11th of September. In this case, SPS Technologies Limited was the principal employer of SPS Technologies UK pension plan. A mistake in the scheme's trusted and rules was discovered, which, unusually, provided an uplift to deferred members who took early retirement, but did not apply an uplift to those in active employment who took early retirement. The mistake was originally made in 1998, and despite 2 further amendments to the scheme documents in 1999 and 2003, it went unnoticed for over 20 years. SPS undertook an extensive investigation into how the mistaken rules came about, with a view to making it clear to the court that the 1998 deed contained an error. SPS then applied to the court for a summary judgment, seeking the equitable remedy of mistake on identifying an error. Just as a bit of background, a mistake will be rectified by courts if 1. It is proven that, as a result of the mistake, the document contained in it fails to accurately reflect the original intentions of the parties, and 2. It is not possible to correct the mistake by another method. The court in this case granted the order for rectification. The effect of rectification is for the written document to be amended retrospectively to the extent that it reflects the terms originally intended by the parties. In other words, to put the parties back in the position they would have been had the mistake not been made. When making this decision, the court considered various factors, including that the scheme had been administered, regardless of the mistake, on the basis that the actuarial reduction applied to transferred members who took early retirement from deferment. This continuing conduct after the date of the 1998 document was powerful evidence that the error had not disturbed the status quo from the first occasion when the error was said to have occurred. Importantly, and unusually, the power to amend the rules was a unilateral power, and so only SPS could approve any amendments. No evidence was available to show that the mistaken intention had been discussed in any way with any other party. It may be the case, in a pensions context, that it will be permissible to allow rectification where it can be clearly implied that the parties did not intend to effect a particular change. For unilateral powers to be rectified, in the same way as for bilateral transactions, there is a need for the party or parties who made a decision to provide convincing proof on the balance of probabilities of the intention. This can be difficult as effectively the party who signed a document is now having to prove that despite having looked at the document and signed it, they actually didn't mean to make the change set out in the document. On the facts in this case, SPS's intention was not in dispute, and indeed the trustee's approval had been obtained for each version of the document being amended, and each of the documents were executed on behalf of SPS and the trustees to the scheme. While this decision is fact-specific, it could have wider application, especially when dealing with unilateral trustee amendment powers. In most cases, I expect that the employer's and trustee's intention, by the time they execute an amendment, will be aligned. This concludes this episode. Please feel free to email me with any comments or questions on this episode to bbrown@mayobrown.com. This episode is an overview of the law, and how the law and guidance arising from these cases will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances. Thank you for listening.